Thank you for joining us today. We're going to talk briefly about Brexit and what it means for Chinese companies, Chinese investors, and other interested parties. And we've got a panel of speakers today from Taylor Wessing who are going to speak about various different aspects of Brexit and how it can affect investors and companies from China and their relations with the UK. So Molly, if we can go to the first slide. So these are the four areas we're going to talk about. The first is an introduction, which will be from me. So moving on to the next slide. So my name is Robert Fenner. I'm a partner at Taylor Wessing. I've been working on Chinese-related matters for the last 15 years or so. Taylor Wessing is a global law firm. We've got over 1,000 lawyers, 28 offices in 16 jurisdictions, including our Chinese offices in Beijing, Shanghai, and Hong Kong. And we've also got Chinese lawyers working in our offices in the UK, Germany, and in other offices around the globe. We are particularly focused as a firm on the sectors of technology, life sciences, private wealth, and real estate, and we act for many Chinese companies in those different sectors. Next slide, Molly. Now, Brexit. The UK, after several years of negotiation, finally left the EU on the 31st of December, that's 2020. We have now left the single market, and we're therefore a third country as far as Europe is concerned. The deal under which we left was one in which we don't have very many rights as far as services is concerned, but we do have extensive rights as far as the movement of goods and products across the borders are concerned. So it's broadly a tariff-free deal that was done, and it's been pretty well received in the UK, and it should give us continued access to the European markets for all aspects of the movement of products and goods. Service is something that we'll have to come back to as a country later on. We can expect now that there will start to be material divergences between EU and UK law. Hasn't happened immediately, but I think that over time you will start to see that the UK will legislate differently to the direction that the EU takes with its laws. So moving on to the next slide. The way in which the agreement between the UK and the EU works means that UK law will be the predominant system of law here. We will no longer be subject to EU law. And in fact, what will happen is that to the extent that domestic law is inconsistent with EU law, domestic law will have direct effect, and that has been set out in Section 29 of the trade agreement that we've reached with the EU. So in essence, the UK has done exactly what Boris Johnson promised, which is it's taken back control of its laws, it's taken back control of its borders, and the UK will no longer be subject to the jurisdiction of the European Court. So in all these ways, the UK has become very much an independent country, separate from the laws and regulations of the European Union, and now looks forward to its place in the global trading environment as it seeks to strike up more trade agreements with other countries around the world. In the next slide, we will hand over to Sean, I think, who's now going to talk about how immigration law will work under the new treaty.
Hi there, and thank you very much for participating this morning. Robert mentioned the control of borders and movement of services, and immigration and movement of people is very much one of the reasons for Brexit happening. One of our government's policy statements from February 2020 was this: we need to shift the focus of our economy away from a reliance on cheap labour from Europe and instead concentrate on investment in technology and automation. Employers will need to adjust. And I think one of the most important things to highlight here is that for China origin businesses, the changes to the immigration system are in many ways beneficial, partly because of that policy aim of rebalancing our economy towards technology, towards areas where there's automation and there's been investment in new ways of working, where of course China has a lot of leadership and a lot of offerings that are important to this focus. And also because China origin businesses are already familiar with an immigration regime in the UK, where you need a license to employ people and to move them from China or from other countries into the UK. So China businesses have two advantages there: the industrial areas of specialism and focus that Britain wants to look for immigration from, and also because you're already familiar with the system of sponsor licenseship and moving migrant workers, whereas EU origin businesses will be less familiar with that. In my time, I'm going to focus on some of the changes that are happening, not describing the existing situation. And I'll try to talk about the impact on your EU nationals that China businesses employ, as well as on China citizens. So one of the most important things to highlight for your EU nationals or EEA nationals, because this includes people from Switzerland and Norway, for example, is that they may be here lawfully now, but by the 30th of June, any of your European employees must apply for what we call settled status if they've been here for 5 years, or if they've been here for a shorter time, they must apply and register as pre-settled. And unless they do that by the 30th of June, they're going to have trouble in terms of being able to demonstrate they're lawfully here after that. So they need to take for the first time some steps themselves to regularize their presence here and be able to demonstrate that that is here. It's not an obligation for you businesses, it's an obligation for the individuals themselves, and you are entitled to rely on existing documentation that, and checks that you've already carried out. But we're seeing a lot of businesses support the individual workers who come from Europe in telling them how to get information and how to make these applications. They're very easy. You don't need lawyers. You can use a digital app. And a lot of EU citizens are doing it for peace of mind in case they get questioned about their presence here after the 30th of June. So that's an easy, cheap support measure that you can adopt to help your EU nationals. Business travel is probably one of the biggest areas of change, and we're going to see some difficulties for EU citizens coming into the UK and UK nationals travelling on continental Europe. Up to now, it was possible for British citizens to travel anywhere in Europe without a visa, and it's still possible to do that, just as EU nationals can come here. If you come here from China, as you know, you need a visa to come here as a visitor anyway. If you come here from Europe, you don't need a visa. You can just arrive. You can make short trips. You can attend conferences, training, maybe even do some maintenance and installation. And similarly, UK nationals can travel out into Europe for a number of days. And this is the biggest change you need to bear in mind. So if you have sales people or engineers or business leaders who travel regularly to Europe, you need to bear in mind that there is a maximum limit of days in which they can work in the EEA. And that limit is 90 days in any rolling period of 180. So you can travel in for blocks of a week or for more or less 3 months consecutively across the EEA. But once you've reached that limit in any 180-day period, you will not be allowed to work in European Union countries. So it's going to be very important going forward that for EU nationals who travel from UK, you count the number of days and keep an accurate record, because they may be stopped at the border or they may be removed from a country, and that can have dramatic impact. So you're going to need to have better record keeping perhaps than you have now, and maybe more centralized record keeping of the movement of your UK nationals into Europe. I mentioned at the start that there are a couple of ways in which the reforms benefit China businesses, and the skilled worker changes are an example of that. Essentially, European countries are subject to the same rules now on immigration into the UK as China is already. And while the changes are aimed at making it harder for cheap European labour to come here, in many ways they also benefit China businesses in specific details. For example, if you look at the right-hand column of the slide here, if you want to move a worker into the UK from China, you need to get 70 points, and they need to be sponsored for a job, and that gives you a certain number of points. But one of the beneficial changes is that the level of English language skill now needed to move into the UK is lower. It used to be degree level, university degree level. Now you only need school leaver level English to have enough points towards qualifying to coming here. And if you are moving a worker, for example, from Canada, who might have Canadian citizenship, because they've grown up in and are coming from an English language environment, it's assumed that they have the English language skills, so they automatically get the point qualification. I'm going to give you some other examples where the changes here help employers and will help China clients. There used to be a minimum salary level of £30,000 for the job to be able to move a migrant worker here. That's been reduced now by nearly £5,000. And actually, it's possible to employ people here as a skilled worker if they're paid just over £20,000. And that's because we have a system where you can trade lower salary against other attributes. For example, if somebody has a doctorate from university, or if somebody is working in specific scientific or technical or engineering applications, then they don't need to earn as much money because we have a skills shortage in those areas. And another barrier to China inbound migration that has been removed is the removal of the need to advertise for a job in the UK before you move someone in from China. There used to be an obligation to have what they call the resident labour market test, where you advertise for a number of weeks in permitted ways, online, job centres and so on, before you could make the application. Now you don't need to have this advertising and fail to recruit in the UK. You can just post someone from overseas without the advertising test. And the only real test is the job genuinely the one that that you describe it as. So there will be an enforcement audit process once people are here, but it will become easier and quicker to post people here from China. Now I'm going to go on to the next slide, having given that good news for China workers. The second major way that you can post people into the UK, apart from sending skilled workers from overseas, is what they call the intercompany transfer route. And this has historically been one of the major ways that China businesses send people into the UK, because it used to avoid the need to advertise. But you don't need to advertise now anyway, as I've just said, for skilled workers. So it could be that it becomes a less popular route to move people into the UK. And one of the reasons why it might be less popular is the salary level for an intercompany transfer is higher than a skilled worker hire. Approximately, you need to pay someone just over £41,000 salary, so that's higher than the skilled worker. Also, the skills threshold is a higher skill level for intercompany transfers than the skilled worker. But there are reasons why you might want to use the intercompany transfer route. This is the fifth bullet point down towards the bottom of the slide. One of those is there's no English language requirement at all. So for the skilled worker route, you only need school leaver English language, but for the intercompany transfer route, you don't need to speak any English at all. So that could be a reason to use this. But as I say, there are difficulties in using intercompany transfer. One is the higher skill level, one is the salary, and a third trap is that you need 12 months employment back in China or elsewhere in the group before you move the employee into the UK, so that they need to be an established employee already. And that's unless they earn just over £73,000. So intercompany transfer is still there, still going to be popular, but maybe you might be thinking about using the skilled worker route instead, especially for new hires or people who have worked with you for less than 12 months. So going forward, things to look out for now. People on the call should have sponsor licenses already, but if you have a very much UK and European workforce here, you might need to get a sponsor license now to cover your European nationals. think about supporting your EU workers with helping them understand how to get settled or pre-settled status. And look also at the kind of visas you might need. You might want to reassess whether you use intercompany transfers or actually take advantage of the easier immigration system for Chinese clients to send skilled workers from other countries into the UK. And it's so strange to be talking about our immigration routes becoming in so many ways easier when we know that immigration was one of the reasons for Brexit and for a reason to take back control of our borders. But you can see that they balance out because it's cheap European labour that we don't want. We do want skilled and useful jobs coming here from other countries, including China. I'll just talk quickly about two other things. One is the last point on the right-hand side of the slide here, which mentions discrimination risks on recruitment. I mentioned that because it's going to become harder for EU nationals to be and remain here, and they need to have settled status in time. Some employers will be worried about whether they should employ EU nationals now. The answer to that is it's fine as long as you get their passport or their European identity document. And it's probably not correct to ask them to prove that they are settled here or have pre-settled status, because they could claim discrimination against you. And definitely you should not look away from hiring EU nationals just because it's going to become harder. So if people are looking at recruitment and still want to think about EU nationals instead of posting people from China or British hires, you can do that. You shouldn't have a policy that says, let's forget about EU nationals because we know it's going to become difficult. But there are some measures you can take to still check people's status, and do talk to us if you're concerned about whether you should hire EU nationals in comparison to somebody else. Very quickly, because time is short, in the slides at the end of the deck that you will have on screen and we can send out to you, you'll see there's some guidance about what to do about employees who may be temporarily in another country. Robinson COVID or Robinson Crusoe people who are stuck in the wrong country because of COVID and cannot travel. You'll need to think about data protection, about tax, about if you're a financial services or a telecoms or a life science business, whether you're complying with your regulatory obligations in relation to people who are temporarily in the wrong place. And I know Vin is going to talk about data protection later in these talks. If you have got people overseas now who shouldn't be there, take care about trying to move them back to the right place quicker. And look at having some policy adjustments to cover the period now while it's an emergency under COVID. My last slides talk about what law could change in the European between the UK and the European Union. Robert mentioned this at the start. I'm not going to talk about this now unless anybody has any specific questions, but there are some areas where our employment law could become more favourable to employers, especially around record keeping, working time, and also around disputes. As you know, it's quite common to have employment disputes in the UK, and there is a big possibility of changes to our dispute system to make it harder for employees to bring claims, and maybe easier for employers to restructure or to discipline employees without being concerned about litigation. But that's all I'll say on that for now. Thank you.
Thank you very much, Sean. So we're just waiting for the slides to refresh. And good morning, everyone. My name is Vin Banj. I am a data protection privacy specialist with Wessing, and today I'm just going to be walking through with you just a brief overview of GDPR and how it impacts on organizations, but also just to bring you up to date on some of the key developments we've seen around Brexit, which also impact on GDPR. And the impact on GDPR is very much a real impact, not only for businesses that are in the UK now, but for businesses that want to come into the UK, or businesses that want to operate more broadly across the European continent, whether that's with the UK or separately across the EU or the EEA as we see it, but also impacts on organizations like Chinese companies, for example, and it is not unique to China, but any other country outside of Europe, for example, that will have operations, will have services that target customers or consumers, for example, in the European market. And from that context, we now have a situation where GDPR, which was a European concept, a data protection law, will continue to apply in the UK, and we always suspected and knew it would do. So that's probably the first most important thing to mention. Brexit does not mean that GDPR disappears in the UK. Quite the opposite. GDPR has got a strong fundamental backbone to data protection law in the UK, and we see that continuing to develop going forward. The slide that you see at the moment is just to highlight how extensive the nature of personal data as defined under the GDPR is. It is so easy to be caught by personal data definitions, so easy to be caught by the definitions of processing and so on under the GDPR. So if you're any business that is collecting information from individuals in the UK, whether you're established in the UK or not, and I'll come on to that point, but if you're collecting information, whether that's more direct information, names, addresses, emails, and so on, but even the indirect information that identifies individuals, whether that's images, CCTV, whether it's online activity or metadata, all of this now counts as personal data under the GDPR. So it's very extensive definition under the GDPR, and it's quite difficult in many cases to carve information outside of the definition of personal data within the GDPR. There is also greater protection afforded under the GDPR to a certain category of information. That category is referred to as special, or sometimes it's still referred to as sensitive data. So it's information, as I list on the slide for you, for example, around an individual's health, their sexuality, their sexual behavior, political views, their religious affiliation, ethnic origins, trade union membership, and also, as we now see specifically mentioned under the GDPR, including biometrics. So this data is not only personal data, but actually is afforded greater protection under GDPR. So you have to look even more carefully around how you legitimize the collection, the use, and the compliance you need to build around that type of data. And there are extra protections that we're seeing coming into very particular areas, such as the use of artificial intelligence, and also concepts of compliance that we're seeing, such as privacy by design or privacy by default, and in particular, a focus that we're seeing at the moment, which is around children's data, or children's GDPR as it's referred to. So a lot of developments in this area, and it's very, very easy for companies to be caught by GDPR. So if we look onto the next slide, what we begin to see here, just wait for the slide, there we go. So what we have under the GDPR is, and actually this has been around for some time, so this is not entirely new under GDPR, but we have a range of principles. We still broadly refer to them as the 7 principles. They're actually only technically 6, but there is a 7th, as we refer to it, which is a data transfer restriction, and that's probably one of the key issues with regards to Brexit, and I'll come on to that on the coming slides. But you'll see there is a range of principles that all govern how data is collected, the nature of lawful collection under the GDPR, and the steps you need to take, such as transparency, such as assessing the lawful grounds under which you are permitted to collect data, or certain types of data, the steps you need to go through to consider why you're collecting the data, what happens to the data, often referred to as data mapping. And so there's a whole regime of compliance and accountability that is introduced into GDPR through these broad principles, which are quite extensive when you're capturing lots of data. And some of these issues are still very complex issues for many companies to be able to deal with. And we are now beginning to see, and I'll talk about some of the very last slide, some fines from the regulators into relation to the complexities of trying to address some of these fundamental compliance points. The point I want to focus on maybe for the time being is the so-called seventh principle, which is the data transfer restriction. And on the next slide, what we'll begin to see here is the importance of the data transfer position under GDPR. Let me just step back for a moment, because this is new under GDPR to a degree, but it is a principle that has been around under the previous legislation as well. So that the principle here is that within Europe, we've always had a zone of data protection law, a regime that has protected the rights of individuals and has placed obligations on organizations or businesses that handle that data, and also forces organizations to look at the role under which they are handling the data. For example, you may be a data controller or you may be a data processor, and the obligation sets are quite different depending on which role you are undertaking. So given that we've always had this common baseline of protection, this data protection zone across Europe, we've always been able to allow the free movement of personal data within this European data protection zone. Any movement of that data outside of the European data protection zone has always been prohibited. There have, of course, been certain derogations or permitted routes to legitimize the flow of data. And some of these you may well have already come across before. There are commission adequacy agreements, the so-called standard contractual clauses or model clauses. In other words, a contract that you can execute between organizations that are responsible for exporting the data outside of Europe with an organization that is importing the data outside of Europe, in other words, that third country. There is also other routes such as binding corporate rules, which are quite extensive, often referred to as the gold standard of data transfers. And this is where you would make sure you are achieving a very high level of data protection compliance around the whole process that you have for gathering, capturing your whole environment and ecosystem that processes data within your group of companies. And this is designed for groups of companies and multinational businesses that have groups of companies. And then you would wrap that compliance up so you can demonstrate it through a formal process of BCR applications, and you present it to one of the EU regulators. The EU regulators then would assess it, and if they're happy, they'll apply a stamp to it and say, here you are, you have a valid BCR. And if you have a valid BCR, you don't need any other steps such as contractual measures to otherwise legitimize that flow of data. There are some minor derogations that apply, such as consent, but these are very much diminished in their application under GDPR because there is now so much more of a heavier obligation. If you are wanting to use a derogation like consent, and it's so heavy that it's almost virtually impossible now to use consent, particularly in contexts such as employment or consumer data, where there's often perceived to be an imbalance of power between a data controller and an employee or a consumer. That otherwise means consent isn't necessarily freely given. So there is still very much a minefield around how you legitimize personal data, but it has always been very possible to export the data outside of Europe, providing you go through the right position. As I mentioned earlier on, now as we've gone through the process of the last 12, 13 months of finally sort of transitioning out of Europe and becoming a third country, we have the position now where in the UK, we have our own very specific legislation that by and large mirrors the EU GDPR. So the EU GDPR is now on the UK statute books. The package of data protection laws around that, for example, the package of laws we often refer to as e-privacy laws, which govern important areas like marketing by electronic means, so email marketing and digital marketing campaigns. That is also transposed into UK law, and then that's packaged together under what we are currently calling the UK GDPR, the UK Data Protection Act 2018, which has been updated this year to take into account all of these changes. So GDPR very much alive and kicking on the UK statute books as we have it. So if we move to the next slide, please. So let's just look at this from a variety of different concepts, because with the previous position where we've had the ability to just move the data freely within Europe without necessarily considering any further how that data moves or where it moves to within Europe, we're now in the position where the UK is a third country. So we do have to look at the very separate position. What if the data flows into Europe and from the UK? And what if the data flows the other way around? What are the positions there under GDPR? And there are, at the moment, sadly, still an interim position that we're having to deal with. And let me just summarize that for you. So where we have data that flows from the UK into the European Economic Area, at the moment, that's okay. The UK and the UK data regulator, the Information Commissioner's Office, the ICO, have already deemed that any flows of data from the UK into the EEA is adequate. We recognize that the European Data Protection Zone provides for an adequate regime of data protection, and therefore this adequacy that exists for those exports outside of the UK is fully recognized, and there are no further steps that need to be taken. So if, for example, you're a Chinese business with operations in the UK and also operations across Europe, you have shared systems and technology and people, therefore data is moving in that dynamic way. For the flow of data from the UK to the EEA, not an issue, no problem at all. Where there are countries that the European Commission, and there are very few, but there are a few countries that have received this adequacy status outside of Europe. And some of those major territories include, for example, Japan. Very soon, Korea is expected to join that list. China is not on that list. Israel is on that list. And just a small bunch of much smaller jurisdictions. Data can flow freely from the UK to those jurisdictions, and there is a system of reciprocity, so it can also flow from those jurisdictions into the UK and out as well. No further steps necessarily need to be taken to ensure that that flow of data is adequate. Flow of the data from the UK to the US in particular is now much more complicated, not necessarily because of Brexit, but because we've seen a development in the law often referred to as the Schrems development, where the use of the available tools such as standard contractual clauses alone are no longer necessarily sufficient unless businesses conduct another layer of check and verification of the law that exists in the country of import to make sure that those model clauses can actually survive in their entirety without local law of the importer eroding that contractual adequacy that flows between the parties. So it's much more complicated now, specifically between the UK and the US. That was the specific issue in hand under the Schrems case, as we saw, which is a European Court of Justice case. And because that was decided before Christmas, before the withdrawal agreement was finalized, that degree of jurisprudence still lives on in the UK. So we are still following that as a position of case law that has applicability. So that will also apply to countries like China, for example, and India and South Africa, all other third countries that are very typically seen as data importers, particularly where technology and data centers and large swells of business activity and economy is concerned. So an extra layer that has to be addressed, where we're talking about data flows from the UK to those countries like China and the US, above and beyond those measures that we've just mentioned. So on the next slide, we begin to see how the picture looks in terms of flows of data that are coming from the European Economic Area into the UK. Here we still have a partial solution under the withdrawal agreement, but it's not a full solution. Often we're referring to it as a bit of a lifeline. There is a 4, possibly 6-month transitional period. So a month has already gone by, so it's now 3 months, by which data flows can continue from the European Economic Area into the UK without steps needing to be taken. There is a deemed adequacy that exists right now, but only for this limited period of time. Why do we have this limited period of time? Because during this period of time, the European Commission is assessing a formal application from the UK to be considered as an adequate country in the eyes of the European Commission, and therefore to the benefits of those data exporters that are within the European Economic Area. So at the moment, we have this little lifeline, but the reality is we're still playing a bit of a waiting game. We still don't know whether the European Commission will grant this adequacy status to the UK within the 3 months. And if it looks in month 4 that this may not happen, then it's possible that the European Commission and the UK negotiations will stop there and it won't be extended to 6 months. If it looks like we're nearly there on that adequacy decision, then it's likely that the negotiation will lead to someone pressing that button and agreeing on another 2-month extension to 6 months, whilst they just finally conclude the position under adequacy. So we have a bit of a lifeline, but the clock still ticks from this particular perspective. What's our gut feeling? What do we think is going to happen here? And it's interesting because commentators seem to be very split on this, and it's rather binary. We either will receive adequacy or we won't. I'm not certain that it's going to be as simple as the UK receiving adequacy simply because the European Commission has an application and they are considering it. If we look, for example, at what the UK's regulator is saying, whilst they've welcomed this lifeline, this further little extension, whilst the European Commission assesses adequacy, the ICO has actually suggested that companies seek to put in place a solution now and not wait for the adequacy decision to come through. So the advice at the moment is, if you are, for example, a Chinese multinational business that has operations across Europe and that data is flowing, that you should put in place a solution such as standard contractual clauses, and also have in consideration how you will deal with additional layers of risk that have been identified through the Schrems decision, and have that put into place before the expiry of this 4-month deadline. And that's what the regulator is saying at the moment. If you're a business that already has a BCR, then there are steps that you need to take place there, because the concept of the single lead authority across Europe, well, that will no longer include the UK ICO. So the UK ICO will continue to have a close working relationship with its European neighboring regulators in the data protection environment, but it will no longer be part of that same lead supervisory authority. So there is a process that you need to think about to then choose your supervisory authority in Europe, distinct from and probably parallel with the UK ICO that will take literally oversight of your UK data operations, and swing your BCR around to a European authority and have them reassess it under the new landscape that we have right now. So on the next slide, if we can move on to that, please. What are the other issues that you need to be aware of? And there are some issues to be aware of. Under the GDPR, we have this concept of representatives or nominated representatives. And in fact, this concept has been around under previous law since the mid-1990s, but it really wasn't enforced or looked at with any degree of seriousness at all. And the concept here is that if you are a business, for example, from China, and you are digitally or through some form of internet-based or web-based offering, targeting goods and services at the European market, but you have no actual presence in Europe, then GDPR will apply because you are capturing data and processing data in relation to EU data subjects. And where you don't have that presence on the ground, GDPR requires that you nominate a representative. And there is a minimum defined role as to what the representative has to do, but at the very least, the representative is there so the regulator and European data subjects, employees and customers have the ability to contact someone locally to enforce their rights or raise concerns around the use of their data, rather than have to find that person that is outside of Europe and in China, for example. So we've always had this concept of a European representative. Of course, now the UK is outside of Europe for those purposes, and we have our GDPR. We now have the concept of a UK representative. So not only will businesses, such as, for example, businesses from China that are targeting their goods and services to the UK market, have to consider whether or not they need a UK representative. But if, for example, you're a Chinese business and based in Europe, but not actually based in the UK, then European operations, if they are the controller in relation to the UK data processing activity, will also need to, as an EU-based business, need to nominate a representative in the UK as well. So there's a degree of compliance now that we're seeing, which is different to what we saw before. So some issues to consider there. I mentioned the lead supervisory authority point a moment ago. The UK ICO will become the supervisory authority under the UK data protection and GDPR regime. So you'll need to consider, does the, for example, data protection officer obligations apply? How will you fulfill that? Where will their location be? Will you use a group officer? And how do you update the UK ICO and be on their register to tell them who your data protection officer is? You'll need to think about the agreements that you have in place and look at how your agreements that support your technology, your infrastructure, and also your operations, and where the backbone of that is also reliant on data, how the flow down and flow up of those agreements also take into account the export of the data and this process of compliance that follows. Can we move on to the next slide, please? So just to mention on a point, and don't often like to finish on a necessarily a negative or a overly scary point, but we have to be very mindful of the risk under data protection laws and under GDPR. The fining regime that we have in the UK is very reflective of the same regime under GDPR. So you could face fines of up to 4% of the global annual turnover of a business, and if your turnover is very much assessed on the global operations, and that's still made very clear by the UK ICO. So it's a very heavy hitting fine that could flow if you're not complying with the GDPR. And we have to be mindful here that what that means is, under the GDPR, we now have a regime of frontline compliance obligations. And this is probably the key distinguishing difference of GDPR compared to the previous regime. Compliance is now a frontline obligation. Accountability is a frontline obligation. So even if you don't have a data breach or a security incident, failure to show that you are compliant, and you can failure to demonstrate accountability of compliance across those principles, can result in a fine for the sort of figures and percentages that we're seeing on the screen. You could also attract regulatory attention, audits, investigations, prosecution by the regulator. We're also seeing now where compliance has been shortcoming, litigation flows. So individuals have rights, and we are seeing group or similar to class actions where individuals are coming together. At the moment, there is a group action against British Airways, for example. So not only did they receive a fine of just short of £20 million for a data breach incident, which was reduced from £160 million just simply because of the impact that the COVID environment is having on that business. But the greater issue for British Airways is they are looking towards a settlement of £3 billion towards a class or a group action from individuals who are claiming for their individual losses as a result of a breach. So we mustn't forget the civil litigation issue, as well as, of course, bad publicity. The one point I just want to highlight here as well, and we see this more often than not, that even if you don't have a breach, even if you don't have the attention of a regulator, we're seeing businesses that are losing bids and opportunities. So a commercial loss of business position arises when they cannot demonstrate to those counterparties that they are compliant, or they have a regime of compliance in place, because those businesses have also looked at their compliance and their policies, procedures and procurement rules dictate that before they can engage with other commercial partners and know that the data is going to be safe as it then flows into a wider ecosystem, that compliance has to be demonstrated. And if it can't, often, as we are seeing, loss of bids and opportunities and renewals of contracts. So a lot to consider from that perspective in terms of GDPR, what it means for Chinese businesses, whether you're based in China or have operations in the UK and Europe. So that brings me to the end of what I wanted to cover today on data protection, GDPR, and the impact of Brexit.
Hi everyone, and thank you, Vin. I'm Louise Popple, a lawyer in our UK IP and media team. I'm going to run through the implications of Brexit for the main types of IP right. And if we could just go to the next slide, please. Wait for that to catch up. And particularly focusing today on trademarks and designs and the exhaustion of rights regime, since those are particularly affected by Brexit, and I think will be of particular interest to everyone here. It's worth just noting at the outset that the impacts of Brexit for IP don't stem from the recent EU-UK Trade and Cooperation Agreement. That agreement merely sets out minimum standards for IP that both parties must adhere to, and all of those the UK and EU already achieve. So the Trade and Cooperation Agreement doesn't really change anything from an IP perspective. Rather, the significant impacts that Brexit has on IP stem from what was agreed in the withdrawal agreement well over a year ago now. So if you're used to hearing and reading a lot about the impact of Brexit on IP, that's because we've known what that impact will be for quite some time now. And it's just worth reiterating that the Trade and Cooperation Agreement doesn't change that. So if we move to the next slide, please. So starting first with trademarks and designs. An EU trademark is a pan-EU right. So you file one application and it gives you protection in all EU member states. But as a result of Brexit, these EU trademarks are no longer going to cover the UK. So there is a gap in protection now geographically, where a person has an EU trademark. Previously, that would have covered the EU, including the UK. Now it won't cover the UK. However, the UK government has agreed to plug that gap by separately protecting these rights in the UK. And that commitment was twofold. So firstly, for every EU trademark that was registered at the end of the transition period, the UK has created a new UK right called a comparable UK trademark registration. These new UK rights have been created automatically and for free, and they mirror the parent EU trademark in every respect. So they have the same dates, same filing dates and renewal dates, and they cover the same goods and services and so on. The position is slightly different for EU trademark applications that were pending at the end of the transition period. If UK protection is required for these marks, you must now refile for the mark in the UK. But if you do that within 9 months of the end of the transition period, so by the 30th of September this year, you can claim the same filing date as the corresponding EU trademark application. The same applies to international trademarks, which designate the EU, and a very similar regime has been put in place for community designs, which is another form of pan-EU IP right, which covers the look and feel of products. Next slide, please. So this might all seem relatively straightforward, but the implications of this splitting out, as it's been called, are quite varied and significant. We've put together a checklist for brand owners, which I've included as a link on this slide. You'll see the penultimate bullet point in there, links to that checklist. It's quite a straightforward list of all the things that you should be thinking about doing now if you are the owner of an EU trademark or a community design. I'm not going to go into too much detail on all of the implications here, but just pulling out a few. Firstly, obviously, if you own any EU trademarks or community designs, you will now also be the owner of these comparable new UK rights. You won't have received a registration certificate or anything to tell you about these new UK rights, but you will own them. And if you want to look, you can see those rights on the UK Intellectual Property Office database. Obviously, you should think about copying those rights onto any database of IP rights that you hold internally. And the representative for these new UK rights will be the same as the representative for the corresponding EU trademark or community design. But it's well worth trying to appoint a UK representative if you can. It's worth adding that because we have EU offices and EU qualified lawyers in our team, our London office can continue to advise clients on EU trademarks and community designs. And obviously, we can also help with the management of these new UK rights. Secondly, going forward, you will obviously need to remember to file separate trademark applications for the EU and UK if you want registered protection in both areas. And particularly worth remembering this 9-month period where you need to refile any EU trademark applications that were pending at the end of the transition period. Those need to be refiled in the UK if you want UK protection, and there's that advantage of doing so within that 9-month period from Brexit, the end of the Brexit transition period. Really importantly, disputes. The splitting out has a significant impact on disputes involving EU trademarks and registered community designs, unregistered community designs. That includes current and future disputes. It's not just a question of service and enforcement in disputes now being potentially more sticky. This splitting out of rights can affect the strength of a party's case. And that includes not just in future disputes, but in current disputes. UK-based litigants are particularly at risk of finding themselves in a worse position in any pending disputes. So that's something that needs to be looked at in detail on a case-by-case basis. So if you are involved in any disputes, whether at the trademark registry in the UK or at the UK Intellectual Property Office or, of course, in court, this is something that's obviously well worth seeking advice on. If you have given or taken security over any EU trademarks or community designs, or you've granted or received any licenses over these rights, you should be thinking about recording that security interest or license against these new UK rights at the UK IPO and elsewhere. That won't happen automatically. You need to separately record them in the UK, even if you've already recorded them at the EU Intellectual Property Office. And there are many other areas where this splitting out has an impact. It has an impact on the way agreements should be drafted going forwards, on the way clearance searches should be conducted for new brands, and on customs notifications. So if you have any notifications in place to allow customs to seize potentially infringing goods at the borders of the UK or EU, these may need to be refiled, and many, many more implications. And obviously we're happy to advise on those in more detail. If we can just skip through to the next slide. Thank you. So that was all I was going to say on the trademarks and design side. On the patent side, Brexit has less of an impact because there is currently no pan-EU patents as such. Patents are governed by a separate European convention, which is not something governed by the EU. There is a proposal for a pan-EU patent right in process, but that has hit some hurdles. And obviously, if that does go ahead, that wouldn't cover the UK, and the UK wouldn't be able to take part in that. Really, on the patent side, or for those who have interest in patents, the main implication of Brexit is around marketing authorisations. So I'm not going to say anything more on that here, as I don't think it will be particularly relevant to many of you, but obviously we are able to advise in more detail on that separately. Next slide, please. On the copyright side, the main issue is that there really is scope for UK and EU law to diverge going forwards, as really there is for all IP rights. But that's particularly apparent for copyright, because the UK is not going to implement a major new directive, the Digital Single Market Directive. So really here we already have that directive needs to be implemented in EU member states by June this year. So at that point, we'll see two different regimes in place, one in the EU and one in the UK for those matters that are covered by this directive. And this will particularly impact platforms, creators, news aggregators, press publishers, among others. So we can really see there how Brexit is going to impact UK and EU laws, and how there is scope for those to diverge going forwards. As with all IP rights, also obviously there is scope for gradual divergence on the copyright side, and we've listed what that might include here. So there's scope for diversions on things like exceptions to infringement, the term of copyright protection, the subject matter that copyright can cover, so some quite significant issues. Next slide, please. So lastly, I just wanted to touch on the exhaustion of rights regime, because this is also significantly affected by Brexit. So just to remind you what this is about whether the owner of a trademark or other IP right can object to goods purchased in one country being sold or dealt with in another country. And the position is that owners of IP rights can't generally object to goods circulating within the EEA once they've been legitimately put on the market there. But they can use their IP rights to potentially object to goods coming into the EEA from outside of the EEA. And this is really just to do with the fundamental principle of the free movement of goods within the EEA. So to try and illustrate that with a practical example, a trademark owner can't generally use its IP right to prevent, let's say, Levi jeans purchased in France being sold in Germany, but it could potentially use its right to prevent those jeans purchased, if purchased in the USA, being sold in Germany. Now that the transition period is ended, the UK is effectively in the same position as the USA in that example. So a rights holder in the EEA could potentially use its right to prevent Levi jeans purchased in the UK from being sold in the EEA. So effectively, the UK is now a third country as far as the EEA is concerned. But the reverse isn't true. The UK has decided to keep the current regime in the UK as a temporary measure. So the net result of this is a sort of asymmetric regime where goods can't necessarily flow from the UK to the EEA, but they can flow, at least as a temporary measure, from the EEA to the UK. So as far as the short term is concerned, this will be important for those businesses that are used to purchasing products in the UK or manufacturing them in the UK and then importing those products and dealing with them in the EEA. Those businesses will now have to consider the IP position in the EEA when they wouldn't have had to previously. That's the temporary position for the UK. UK government has said that it intends to consult on a permanent regime early this year. So we wait to see if the temporary position is adopted going forwards. If you're a business that manufactures or purchases products outside of the UK and then imports those products for sale into the UK, you may well want to say on the future UK regime. And that's something we can certainly help you with. We've been involved in some of the government discussions on this and are helping to try to steer the direction of the future regime. So next slide, just to summarise the position for IP. So trademarks and designs, as I said, are particularly affected by Brexit, and it's well worth having a look at our checklist or getting in touch if you own any of these rights or involved in any disputes in relation to these rights. Same for the exhaustion of rights regime, the effect is quite significant. On the patents and copyright side, there are some significant but really quite technical implications, which I'm not going to go into here. And overall, there's obviously scope for some divergence of laws going forwards. So that was all I was going to say on the IP side, but obviously happy to answer any questions either now or separately after today's talk.
Thank you very much indeed, Louise. I'd like to thank you very much indeed for attending today. And if you have anything more you want to ask after this session, then our details are on the slides. We can also make the slides available to you. I'm grateful for your participating.